Believe it or not, G is still at it, with not just one, but two further emails since my original polite email to tell G that they'd confused guidance with legislation. And now I know that you all say don't feed the trolls and don't let any of this bother me. Now, in reverse order, it absolutely doesn't bother me. I take this as an opportunity to further enlighten everybody watching as to how misguided some people can indeed be, and just to avoid these pitfalls where other people might just think that said guidance is hard-coded legislation, which it isn't. I'm not going to reference where the guidance was from because it's not fair on them, because to be fair to them, the guidance doesn't even contradict what I said in my original video. For anyone that's not sure what I'm talking about yet, it's the original video where schools can confiscate a phone and other property, and in some situations they can even dispose of it. Now, just to make clear, I said in each of those videos that I don't think a school would dispose of a phone, but the legislation is there to protect them if it's absolutely necessary. For a longer explanation on that, I'll link my second video on this subject in the description below. But I thought, despite saying that I wasn't going to show you the email, I think I will now, because I think now will be a good time to just illustrate just how misguided somebody can really be. Now, I will also reference the law as we go through, so stay with me. But first of all, if you're new to me and you don't know who I am, I'm Daniel Shensmith, a barrister of England and Wales, and I enjoy helping you to understand law. So please do bop that like button and subscribe if you find this content useful or entertaining. But let's go to G's email. Obviously, I'm not going to provide G's name or email address or anything like that, but this will be a useful education on how misguided somebody can be. So G originally referred to Section 72, but actually was referring to guidance. That's the screening guidance from the government on confiscating things. And actually, you'll see in a moment that I quote part of that guidance, which supports the point that I made in the original email. However, G says Section 72 onwards specifically relates to the area you discussed. Schools nor teachers have the right to destroy any phones and materials they can destroy. Materials they can destroy are covered in the earlier section, but can be summarized as these things here. But the guidance doesn't at all say, I mean, it's guidance for a start, but it doesn't at all say that the teachers don't have the right to destroy phones or other materials. Quite the reverse. The guidance summarizes the legislation, but I'll come back to that in a moment. G then goes on to say, which on the one hand, you can think it might be quite polite. You'll see from further on in the exchange that it probably wasn't polite. It was probably very much more tongue-in-cheek and sarcastic. G says that they are currently cooking the Sunday roast, but if you wish for additional information regarding the matter and the relevant citations, I can fire those over to you, like I can't find them for myself, which obviously I can. Goes on to say, and this is like one of those bingo scenarios where these kind of views that are fired at me are usually one of a short list. And this is a common one. Very shocked you repeated the school lies and propaganda rather than actually check the legislation. I expected better from you. However, allow me to disprove that just for a moment. If we switch to this one here, this was my original video from 30 seconds onwards. This was the original video. So G says, rather than actually check the legislation. But let's play this very short clip of my original video. So first of all, let's dive straight into the law. The law does protect teachers where the confiscation was lawful. Section 94 of the Education Act of 2006, the Education and Inspections Act 2006, provides that as a disciplinary penalty where the confiscation was lawful, there's a few little things that make it lawful, but we'll come back to those at another time perhaps. But so long as it was a lawful confiscation, it is a disciplinary penalty where an item that a pupil has with them in their possession has been seized and it's retained for any period or is disposed of. So that's the legislation that I referred to, but G, for some reason, said I didn't, but I did at 30 seconds into the first video. G then signs off, God bless and have a pleasant Sunday, professing to be person of religion, which, again, from later on in the exchange, you might conclude otherwise. My response to that, so this is my response now, this section here. Respectfully, you've confused this guidance document with the legislation. The guidance does not override the legislation. See from paragraph 80 of the same document, the same guidance, which provides as follows: confiscation is a disciplinary penalty, and then summarizes the law. The school's general power to discipline enables a member of staff to confiscate, retain, or dispose of, this is my emphasis, or dispose of a pupil's property as a disciplinary penalty where reasonable to do so. So this is the guidance that G referred me to. The law protects members of staff from liability in any proceedings brought against them for any loss of or damage to the item they've confiscated, provided they acted lawfully. And lawfully just means that they've decided what they've done wrong, the student, and this is a disciplinary action. And obviously, for those that are not familiar, certain students in certain schools misbehaving is not just wriggling around in the chair and making noise. Certain professionals are called into certain schools because the students are quite literally throwing chairs at the teachers, and in some cases throwing phones at the teachers. Now, for a teacher to be in that position, they have to have some kind of authority and power to deal with that situation. What would you do? I mean, if you were the parent, would you get annoyed at the teacher for confiscating a phone if the student was throwing it at the teacher? True story, by the way. I was called for advice from a professional that went into a school in exactly that scenario. So that is one of the scenarios where, as a disciplinary penalty, the teacher may confiscate and, in very rare scenarios, may even dispose of said material. And then I provide G with the link to the legislation. G then replies. Now, this is one of the two further replies from G. With another link to another different guidance document, which again, I'm not going to provide because it's not fair to them. There's nothing wrong with the guidance, by the way, but I'm not going to refer to it because G is using it in this way. G says, you're misrepresenting reasonable as defined by the above and numerous other examples. So G is saying that this guidance document here sets out what they consider as being reasonable. And so without going into depth of that guidance document, which doesn't contradict anything I've said, by the way, but they say what they think is reasonable. That is an individual institution that they think is reasonable. But G seems to think, again, that this is the law, which it is not. This guidance document defining reasonable is not the law, doesn't override the law, and is not binding on any other organization. G goes on. Furthermore, the value of the item to be taken into consideration also again revokes any assumed right of reasonability. Therefore, the teacher, if it's deemed unreasonable, will be the subject of arrest for criminal damage, which absolutely not the case. Because, again, if it isn't clear enough, back to the legislation, if it isn't clear enough, a person who seizes, retains, or disposes of the item is not liable in any proceedings. So it's nothing to do with criminal damage and is nothing to do with arresting the teacher for confiscating the phone. This is just quite silly. What's funny, G goes on, is the value of the item condition is actually repeated numerous times in legislation. Now, I'm not too sure here whether G's referring to the guidance documents, because some of them do refer to value of the item. But again, if we contrast that argument with the legislation and we search for the word value in any of these sections, value is not mentioned in any of the sections that I referred to in previous videos, where members of staff have the power to search and seize items and so on. The value is not mentioned here. It's only mentioned numerous times, whether it is deemed necessary, whether it's lawful, whether it's reasonable, and that's for the school to decide. And if it's ultimately unreasonable, then that's for a court to decide, but that's an argument for a later date. I dare say most schools will operate with extreme caution if they are taking a phone off a student. I think that goes without saying. But again, G says, if you bothered checking, including the above and below section I quoted you, referring again to the guidance document. Now, once again, G is confusing the guidance document with legislation, which it is not. And if there's any doubt as to whether G is referring to that guidance document as though it were legislation, G goes on in the blue highlighted section, for the record, I linked you to the exact same legislation. That website just reformats it into an easier format than used by legislation.gov.uk. But that's not correct, because this website up here, again, as I said, is an independent organization's guidance document on how they apply the law, because they have the choice as to how they apply this law. Now, again, for the avoidance of doubt, I do not think that the very, very vast majority of schools are going to take a phone off a student indefinitely, or B, much less destroy it. But as I said, there is a defense available if they do so. It's not a right to do so. I mean, this drafted in legislation deliberately, a defense available where confiscation was lawful. So if the confiscation has been done in accordance with, well, either virtue of Section 91, which if we go to Section 91, I can show you here that provides that it's an enforcement of a disciplinary penalty. This applies where a penalty has been imposed on a pupil by a school, etc., etc. So this is disciplinary penalties. But whether or not it is in virtue of Section 91, so long as it was lawful, then the school has this defence available. And most schools actually do say that the student have to hand their phones in at the beginning of the day, and then they get them back at the end of the day, and that sort of thing. And at the very least, if they don't do that, then they're not to bring them out, or they do get them taken off them. That schools do. And that's what they do say. And you've got to love the little winky face at the end here, so that G thinks that they're somehow being clever, referring to this guidance document as though it is legislation just reformatted, but it's not the case. G goes on, instead of, and this is where it gets interesting, instead of misrepresenting the rules that they can destroy mobile phones, which is a blatant lie and contrary to the guidelines in place. Now, as I said, they probably won't, but there's a defence available if they do, for what is deemed reasonable, and also in breach of the examples provided when a duty of care exists for the minor. Now, there is a duty of care. It's a special duty of care for schools. But again, this is confused with the disciplinary penalty of the student. If the school is taking something off a student as a disciplinary penalty, that is nothing at all to do with the duty of care. The duty of care will still exist. The duty of care doesn't fall away and is not really infringed by taking the phone off the student. That's just confused either way you look at it. However, the email goes on. G then says that if the teacher takes the mobile phone off the student and destroys it, the child's father then proceeds to arrest the teacher on the grounds of criminal damage in accordance with Section 24. It's 24A, by the way, of PACE, the Police and Criminal Evidence Act, which means he does not need the police's permission, neither the belief that a crime is sufficient, etc., etc. But this suggests that G thinks that people should go and arrest the teacher for criminal damage. Now, it's worth highlighting here that if the arrest is unlawful, then the person can be charged with assault and false imprisonment. So that is a whole dangerous area we're going into right there. So anyone watching, again, as I said, this is my opportunity to provide guidance, because some people will be forcefully telling other people that this is the law and you're allowed to do this. I strongly suggest that you do not. And then G goes on, bonus points, loving the sarcasm. During the initial arrest, the teacher becomes aggressive and in the process makes an open threat, in which case the parent can use the right to preemptive strike. So now G is suggesting that the parent that is arresting said teacher for confiscating the phone should what? Punch the teacher? A preemptive strike? So this is all very dangerous stuff here. G goes on, you'd probably be far better if, rather than preaching the idiot, and this is where this is really telling for me as to G's state of mind, rather than preaching the idiot power-grabbing attempts of the government to stop the spate of students recording LGBTQ+ and radical left materials in schools by misrepresenting its powers, and would help people more by informing them of the possible flaws, caveats within the legislation that people could use to protest what's being done. So this is the key word here, protest. G's protesting. G's protesting to me that G doesn't like the law. G doesn't like what G perceives to be idiot power-grabbing attempts by the government, which, you know, the government may well be power-grabbing. That's not my place to say otherwise. You can debate that among yourselves. I'm not saying they are. I'm not saying they're not. But criticizing me for telling you what the law is very far removed from me preaching and supporting government attempts as it's put here. And then again, G goes on, again, propagating the lie that they can seize and destroy mobile phones is laughable. Well, they can, because if you didn't catch my previous video, and we jump back here for a second, electronic device here. If an item has been seized and it's in relation to a crime, this is now in the Education Act 1996, explained in full in my previous video. If the item is an electronic device, they can choose whether or not to return to the owner, retain it, or dispose of it, and then go on to consider the data and whether to erase that or not. Back to the email. G also took issue with my thumbnail, which I've pasted in here for clarity. But G says, again, please remove your clickbait headline stating that they can destroy student property without recourse. That isn't what the thumbnail or the title of the video say. G says they confiscate it, nothing more. Well, in fact, that's what the title of the video said. Can a school confiscate a mobile phone? And the answer to that, of course, is yes, they can. But as I said, there is a defense available in legislation if ultimately they decided to destroy it. I mean, they wouldn't, but if it were used for certain things, they would have a defense available if that's what they did. So I reply, and this is where it gets really nasty, which again is why I bring it to you, just to show how misguided some people can be. I reply, politely, respectfully, you clearly don't understand. Here's a fuller breakdown. I link to my second video where I explain the law in much more detail. G replies, again, talking about where it's reasonable to do so. Now, maybe I'll go into greater depth on what would be reasonable for a school to ultimately decide to confiscate and dispose of a phone. I'll go into great detail for that in another video, perhaps. But that is where G focuses their attention here, again referencing the emergency functions and duty of care and so on. But that again is not negated by the school actioning a disciplinary action. Again, as I say, do I think the schools are going to do this? 999 times out of 1,000, no. But there will be that one case where the school decides this has got to happen, and they do take it away permanently. And there's a defense available if they do. Again, as for what's reasonable, I'll come back to in another video. Again, talking about now into proceeds of crime and all this sort of stuff. Name calling again, being persuasive. If you're resorting to name calling, it's never persuasive. So white belt barrister, this is that bingo thing again. I should have a little bingo list of what these trolls come back with. Thinks the school has more power than the police, etc., etc. Well, actually, it's an interesting point because educational institutions have quite literally hundreds of sections of these pieces of legislation that provide what they can and cannot do. And they do have a great deal of power, which surprises a lot of people because they have to, in a sense, police their own premises, police their own organization as a school. However, just before that, G suggests that if I were to remove fingers from I would be able to understand and that it's never reasonable to do so. And more swear language, and then saying that my video is pathetic and I have a small brain and so on and so on. So descended into name calling throughout the remainder of this paragraph here, which is far apart from God bless and have a pleasant Sunday. Now, for all of those of you that take your faith seriously, I apologize, because whilst initially you might have taken this as a pleasant email, when you look at the exchange below, clearly this first one was just laced with sarcasm and wasn't genuine at all, rather disingenuous, I have to say, when it comes down to literally words that I have to blank out because I don't want them going out on this channel. So that just goes to show how far misguided somebody can be. They believe that the schools don't have this power. They confuse guidance with legislation. They accuse me of putting things in the title when they're not there. They accuse me of not looking at the legislation when it is literally 30 seconds into the video, and then ultimately resort to name calling and so on. But otherwise, I hope you found that enlightening. Please do hit that like button and subscribe. And as always, thank you for watching.